Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're going to talk about a very interesting topic regarding emergency motions designed to educate our viewing audience, so please subscribe to our channel. I want to talk about post-judgment emergency motions. What's the scenario? Parties, let's say, get divorced. Doesn't have to be a divorce, but let's say it is. There's a custody order regarding who will have custody on a certain day. Maybe it's something like during the summer, last 2 weeks of the summer, a child will go with mom and then return before school. Something like that, some order. And what's the scenario? The other parent doesn't comply. The other parent doesn't send the kid back. Or worse, the other parent calls up, I'm not sending the kid back. The other parent is defiant. It's not just a mistake or a miscommunication. Outright telling you, Johnny's not coming back home. Johnny doesn't want to go to you anymore. What do you do? What are you supposed to do? Well, and think about it. It's the end of the summer. You got to get your kid back. Maybe the child has to be yet enrolled in school. Maybe it's the first year of school. Maybe there are other things, back to school things that have to be accomplished. Visits to the doctor, medical clearances for athletics that have to be put in place before school starts, all sorts of things. And what happens that the other person won't comply? What do you do? Well, number one, you've got to document this emergency, which means you've got to show to the court what the order is, the fact that what evidence you have that the other person is not going to comply or hasn't complied, why you need the court to intervene. And with all that information, you have your lawyer file a motion for emergency consideration for immediate return of the child. Now, you have to serve the other side. Presumably you know where the other side is. Even if it's out of state, you serve the other side. The court's going to give very little time for the other side to respond because the court already gave an order. And the court already ruled that that child has to be back. And I'll tell you something. The court is likely to give emergency relief designed to enforce its own orders. The fact of the matter is, if you're on the receiving end and you don't have a darn good reason why you haven't sent that child back, you can expect a couple things. Number one, you can expect that the court's going to order that child back. And number two, the court may well sanction you and hold you in contempt for non-compliance with the orders. Why? Because the court doesn't want to have this come up every time there's a vacation. The court is trying to stop litigation, not increase it. And the more one person has a directive from the court and won't comply with it, the more litigation there has to be over it. The court does not like to repeat itself. If any of you have ever been in a hearing, you know that that's the case. The court doesn't like to tell you to not speak out of turn, let alone to violate its orders. The court doesn't like that. So very important for you, if you are in that situation, document the emergency, document what it's supposed to be, show the court why you need this emergency relief, and most important, have your attorney file the appropriate motion seeking that emergency relief. If you have questions about your case, reach out. We'll be glad to help you out.